So we have some very important updates in the critical assault weapon and magazine ban challenges that we're seeking Supreme Court review. The Supreme Court has relisted 2 of these cases and then denied review in one of those cases. But this could be a potential good sign, so let's talk about what is happening. Now, really quick before we jump into this video, if you want to support this channel, please consider subscribing to the channel. Looking at some of my analytics, about 60% of all viewers are actually not subscribed, so consider doing that. Also, click the notification bell, turn on all notifications, because that helps to ensure that YouTube will actually send you these videos. But regardless, thank you guys for your support. Now, as I mentioned in the intro, in this video, we're going to be talking about some very important developments in a few of the cases which are challenging various state bans on so-called assault weapons, and then also those magazine restrictions as well. The critical cases we're going to be talking about are Snope versus Brown, Ocean State Tactical, and then also Gray versus Jennings. Recently, we discussed how the plaintiffs in the Gray versus Jennings case filed a notice to the Supreme Court that they wanted to waive the 14-day waiting period, and essentially they did that so that their cases could be distributed for conference early. Well, we just received an order from the Supreme Court, and the Supreme Court has denied review to that Gray versus Jennings case. However, the Supreme Court has now not issued an order denying the Snope and the Ocean State Tactical case. Instead, they have relisted both of those cases for the January 17th conference. So they have relisted them for conference this Friday. The single denial and the 2 relists of these other cases may be a good sign for these cases going forward and may signal the Supreme Court is going to potentially take some action on one or both of those cases in some form or manner. Now, for those not aware, the Snope versus Brown case in my mind is kind of the biggest case out of all 3 because it deals with a state ban on so-called assault weapons. This case was prior GVR'd, meaning that it was granted, vacated, and remanded by the Supreme Court after Bruin. And this case was recently ruled on by the 4th Circuit en banc panel, and that decision upheld the state's ban using the incorrect military use test. However, despite that improper analysis, this is a final merits decision. The Snope case is once again seeking Supreme Court review, and since it's a final merits challenge on the constitutionality of rifle bans, it is one of the most important in my mind. Now, the Snope case was originally set for Supreme Court conference back last year on December 13th, but then the court preemptively rescheduled the Snope case. It then was set for conference last Friday on January 10th. And now, after that January 10th conference, we have now got the Snope case relisted, and it's going to go to the future conference this Friday on January 17th. Now, that's important and potentially a positive sign for this case to potentially be granted, and we're going to talk about why a single relist or future relists is a potential good sign for this Snope case. Now, in the Ocean State Tactical case, the plaintiffs challenged the state's magazine ban and a lower court denial of a preliminary injunction. Now, this case, unlike Snope, is still an interlocutory case. It's still in an interlocutory posture, and it deals with a preliminary injunction, which was denied, and that preliminary injunction would have blocked the state's ban on magazines that hold more than 10 rounds. That Ocean State Tactical case was also originally conferenced back on January 10th with the Snope case and the Gray versus Jennings case. However, the order list did not deny review to the Ocean State Tactical case, but instead it has also been relisted for this upcoming Friday on January 17th, and so it will be reconsidered along with Snope. Now, the Gray versus Jennings case is a little bit different. That case deals with a challenge to the Delaware restrictions on rifles and magazines, and in that case, the district court denied a preliminary injunction, and that decision was then appealed up to the 3rd Circuit Court of Appeals. The 3rd Circuit, in their decision, sided with the state of Delaware, but instead of looking at the constitutional arguments, the circuit court instead focused only on the preliminary injunction factors. And in doing so, they found that the plaintiffs could not show that these bans actually caused an irreparable injury. So they treated First Amendment harms as per se irreparable, but when it came to the Second Amendment, they said that those types of harms are not per se irreparable. So they treated the Second Amendment as different from the First Amendment, and once again, you have a circuit court treating the Second Amendment as a second-class right. As I mentioned in the Gray versus Jennings case, they waived some of the procedures so that it could go for conference also on January 10th with the Snope and the Ocean State Tactical case. And then out of the conference this Monday on the order list, the Supreme Court has denied review in this Gray versus Jennings case. Despite the fact that this case was denied, there is still a lot of hope when it comes to the Snope and the Ocean State Tactical relist. And it's important that they have been relisted for this upcoming conference. Now, you may be asking yourself, why is the Supreme Court relisting a case so important for these 2 other cases? Well, that's because all Supreme Court analytics and tracking and data of prior cases actually shows that you have a higher odds of getting your case granted review by the Supreme Court if it's relisted at least one time. In fact, according to the data for the court's 2016 to 2020 terms, between 31% and 43% of all petitions that were relisted at least once were eventually granted review by the Supreme Court. And between 66% and 75% of all cases that were granted Supreme Court cert were relisted at least one time. So the fundamental truth has become that a relisted case has a far better chance of getting review by the Supreme Court. Also, according to the data, there is another truth that we need to talk about and will impact some of these cases as well going forward. And that's that essentially multiple relists is not a good thing. So you don't want to see 2, 3, 4, 5 relists of a case, because oftentimes that's a strong indicator that the case is going to be denied review, and potentially there is just going to be a denial and then maybe a dissent written in that case as well. Now, that's not always the truth. There have been multiple situations where a case has been relisted multiple times, like the Bruin case, and there were other very high-profile cases that were relisted multiple times and then ultimately granted review by the Supreme Court. But the general rule is that you want a one-and-done relist of your case. So where does the data and developments in these cases actually leave us now going forward? Well, the first domino really has fallen with the Gray versus Jennings case being denied review by the Supreme Court. And after that January 10th conference, we were expecting to see, some indicators by the Supreme Court about how they were going to deal with this. And when it came to the Gray versus Jennings case, they have denied review to that challenge. However, in my mind, if the Supreme Court was going to outright deny all of these cases, I would have expected that all three would have been denied after that last conference, and they would have been denied altogether on this order list. That means that in my opinion, I believe one of two things will happen going forward in the Snope and the Ocean State tactical cases. Either they will be granted review after this following conference on Friday, or there will be maybe a dissent written in one of these cases, and that's why they're being relisted multiple times, because one of the justices wants to write a dissent in the denial. Now, there's also the potential that the Supreme Court simply got bogged down last Friday because they were dealing with a different, very high-profile challenge, which was a 3-hour oral argument in the TikTok ban case. They're having to deal with that right now. That's very high profile. There's a lot of influence on that, on all sides. And so the Supreme Court kind of could have got bogged down on Friday. They did issue some grants of certs that Friday. None of the cases here were granted that night, but a lot of those cases that were granted review had to do with the government being involved, seeking petitions. And so it's not shocking that they immediately granted review to those cases. And we don't often see that with 2A cases like these. Oftentimes the Supreme Court takes their time, relists multiple times, and it's one of those things that has to go through a little bit more process. When it comes to the Delaware case that was denied this Monday, that could have been an easy out and essentially an easy denial, since that case focused more on the procedural aspects of a preliminary injunction. It's an interlocutory case. It still deals with 2A issues, but it's more procedural when it comes to, the factors for preliminary injunctions. And it could have been that the Supreme Court thinks that they can resolve that issue also raised in the Gray versus Jennings case if they grant review to the Ocean State tactical case, which also is a preliminary injunction challenge. Or they could address that also in the Snope case, dealing with what type of arms are protected and which ones are per se protected by the Second Amendment. So at the very least, we avoided kind of the worst case scenario, which would have been that all three cases would have been outright denied during the order list, but we avoided that, so that's a good sign. So these cases are now entering a very critical stage. All eyes will be on this Friday's conference, and we're going to be seeing how that develops. And then the following Monday order list, we're also going to be seeing what happens. If we see another relist of these cases after Monday, after that conference, that could be a bad sign, but that does not 100% mean that we're going to get a defeat in those cases. Like I mentioned, we've seen other cases get relisted multiple times and still be granted review by the Supreme Court. So that could also happen again when it comes to these cases. So again, very important battles coming up in the following weeks. We're going to be keeping our eyes on seeing what the Supreme Court does, but some positive signs in some ways that they were just not outright denied, because again, that would have been the worst case scenario. Only one of them was denied, and then the other two were relisted, which again, like I mentioned, could be a positive sign. So as we get more information, I will let you guys know. But as always, thank you guys for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.